Well, thanks for staying with us. You're still watching News Night here on Arise News. Well, taking a look at other issues now. Well, the recent judgment of the Federal High Court in Kano as it affects the governor-elect of the Labour Party in Abia State has actually continued to generate some issues. And while some say the decision of the court is capable of affecting the inauguration of Alex Otti as governor of Abia come May 29th, others say the court did not make any pronouncements regarding that. Well, the Independent National Electoral Commission, INEC, has also come on the knocks for not implementing the electoral law to the latter. Well, tonight, we examine the implications of that section of the electoral law and ask whether it shows another evidence of failure by INEC to properly regulate political parties. Well, should we bring INEC and give the responsibility, break INEC and give the responsibility of regulating political parties to another body? Or what should be done really to make INEC be a good regulator of politics in Nigeria?
Dr. Sam Amadi, a Rise analyst, joins us to look at these issues. Dr. Sam, thank you for joining us on Newsnight.
Thank you.
Some have suggested that INEC should be unbundled. Some others have said we should just give the electoral process, the handling of the electoral processes to another body. You see what happened to the issue of Alex Otti, you know. They didn't bring the names of the register on time before a stipulated time and all that. Okay, what are your suggestions?
Well, first, let's understand what has happened. I mean, the case in Kano has a lot of auditors. I mean, Kano, not Abuja or Lagos, of course. One federal high court, one can argue. Two, they didn't sue Alex Otti, but they got a blank declaration against Abia State and Kano State and so forth. Three, of course, the judge did not make any order against Otti, but essentially, I said that not submitting the register 30 days to primary negative voids the outcome. Now, the key question here is that that order, actually, that section, is a section to authorize INEC. So it says, look, you must submit to INEC, even if it doesn't provide for consequences. The question is, did INEC do due diligence? INEC knows this provision. INEC knows that some parties have not submitted. So what did INEC do internally to ensure that those provisions are comply with, and what the INEC do internally to execute consequences for the parties? Now, I would argue that it's between INEC and parties. INEC could penalize parties, but it's also a tool for INEC to validate primaries. So, for example, what that said to do is to say, okay, we used to do direct primaries, where you carry everybody who are not even party members to vote, okay? By that register, you are telling INEC these are the party members. INEC can use that register to second-guess candidates, look at verify candidates and results. But INEC didn't care about those provisions because INEC was not diligent. INEC wasn't focused on anything. INEC was focused on printing ballot boxes, making money, and running shambolic elections. So the key issue is that INEC fails to do the hardcore regulatory work. The idea of the Electoral Act is to create credibility in the primaries so that before 30 days, INEC knows all party members, okay? 21 days, INEC is notified that this primary is coming. So INEC uses those tools, those documents, those material, those reports into it to effectively monitor these primaries. So what should we do about INEC? You don't forget that Uwe's report talked about unbundling, not just election crime commission was proposed, political party registration agency or commission was proposed to have off INEC's responsibilities, which INEC, especially this INEC, has failed to do. I give you an example. I'm in court with INEC now on the issue of campaign financing. INEC has not done thorough regulation that will create a process that someone like me can now say, how did the parties raise money and how much did they spend? Who are benefited? So INEC has not even done the required regulatory work, which is to make provisions for how to report, how to bookkeep to facilitate constitutional responsibility. So there are many missing pieces of the work INEC is supposed to do. And this work are very important in terms of the quality of democracy. Because if you don't regulate finance, you can't regulate the quality of election. You can't even guarantee credibility, fairness of election.
All right.
So this is now another conversation. It's not about Otti. I mean, none of the others will validate him. But it can create a surprise that suddenly, for INEC's gross failure, we could discover that even candidates who won election could have themselves in jeopardy because INEC does not focus on doing what it ought to do. It sit back and assume that those rules, for example, we're talking now about 25%. Didn't we say here, before election, that Sabako is the issue? If INEC was diligent, INEC would make an interpretation and go to the Supreme Court to say, give us an interpretation. So that process would have set
some sort of precedent.
Okay,
Dr. Amadi, while we actually preempt or try to think about what should happen in the future, let's cast our mind back to last week Friday, because you know what, this judgment by that High Court in Kano State has actually opened the Electoral Act and even that judgment itself to all sorts of interpretation. So you as a lawyer, what does this really mean, the judgment as it stands right now, pending if anyone is going to appeal it? What does it mean for the Labour Party, not just Alex Otti, but all its candidates? And with that judgment, some would argue that as it is open, the next political party in line can claim the leadership of Abia State. What does it mean? Help us understand the judgment as it stands.
Very important. Look, two issues there. One is pre-election. So if you're a pre-election matter, then it has to be established within a time frame. They lost that time frame. So you are talking about qualification for election, that this person, because of failed primary, is not qualified to run for election. That's pre-election matter. He ought to have been fired and finished before now. If it is election matter, then it has to be filed through a election petition. So there are so many things wrong with that judgment. But the fundamental thing is, and that's my opinion, that section is a section that relates to party and INEC relationship. It's not a section about qualification of candidates. So it simply says you must submit in 30 days. There are no consequences in that act, and nothing that says that the qualification of who emerges from the primary of party is tied to 30 days submission. So my own view is that section does not determine the qualification of anybody who emerged through a proper primary. It's a regulatory requirement of INEC that INEC should have fixed a consequence. Maybe INEC will refuse to monitor your primary, maybe INEC will postpone your primary, maybe INEC will nullify your primary. The point is, once INEC didn't do that, a candidate emerges, then that section cannot invalidate that candidate. There are issues around jurisdiction, issues around which I talked about, whether it's pre-election or post-election. Even if it's pre, then it has expired. If it's post, meaning electoral petition, it should go through the narrow corridor of election petition. I don't think it's Otti is at risk here. But again, evidence. We didn't see, was a legitimate motion, okay? We don't know whether even INEC has come out to say, truly, these guys didn't file within 30 minutes and 30 days. And which elections are the ones that didn't show? Is it because the elections happened at different hours within a period? Primaries took place at a range. INEC gave you a window. So it's possible that Party A happened less than 30 days. B may happen after. We don't even know whether the argument is that the party did not at all send
its register.
So it will be, if you sustain the legal decision, then you have to cash it out at local level through other applications. People have argued that maybe the PDP or any party can go to court and use that ruling to say, okay, now that this is invalidated, make an order authorizing me to be sworn in. Now, the difficulty is the moment the appeal on declaratory order with no order, mere declaration, then there's nothing to stay. Once it's appealed, then it's now like in abeyance, in the air, in thin air, floating, because the appeal means you are challenging it, and therefore it can be a basis for a court to establish an order. So basically, it's not it's like a sort of Damascus, but not possible to fall because it's tied up in the air and wouldn't fall. For it to fall, then it has to be validated by the Supreme Court, and then maybe now subsidiary litigation. So people can use that order and seek to get order that now has teeth. Meaning
Order.
somebody can now say, okay, based on decision of this court, High Court of Umuahia, declare that I ought to. So that will be an interesting question. But at this point, once they appeal it, then it cannot go to any other court to say that they should base a decision on a declaration that is being challenged in the higher court. But if there was an order, they have to stay that order, otherwise it has effects. Assuming the court says, therefore, orders INEC to withdraw the certificate.
The certificate, yeah.
OTI's team needs to not just appeal, but also get the Court of Appeal to give an order, stay in that action.
The lawyers definitely will be busy. You know, we were thinking that having over 700 post-election petitions in the court was enough wahala, but now we're seeing
more wahala is coming.
Dr.
Sam Amadi,
I must say that your submissions in this night are usually very insightful. Thank you for joining us again.
Thank you.